It's been a while. It's nice to see you.
So Jeff, it looks like we're waiting on Maureen, George.
It's been a while. It's nice to see you.
Unmuted. So we're waiting on Maureen, George, and Dave, it looks like.
The birthday girl's late? Maureen's birthday today.
Amazingly enough, they all just magically appeared in the waiting room.
Perfect.
So, again, just to kind of help, just to want to let everyone know, and before we start, is there are some people that are still in the waiting room, but we're already up to 20 in the meeting. That adding more and more people in gets, I think, harder for you to see. So we just have them there and they can be on YouTube, and we'll let them in when we get to that part. It's not to try to hold them out or be exclusionary. I just want the chair to be able to see people who are raising their hands and do that.
I appreciate that because then I can see everybody in one window.
Yeah.
So it does look like we have all commissioners at this point, and all of the members from the, might be waiting on Matt Fee. But I think I'm going to get going with this remote script and hope that he joins in. That is my thought. So at this point, we're going to begin the Nantucket Conservation Commission meeting for November 5th. As a preliminary matter, this is Ashley Arisman, Chair of the Nantucket Conservation Commission. Permit me to confirm that all members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. Mark Beal.
Yes.
Seth Engelborg.
Here.
Arisman here. Ian Golding.
Yes.
Dave LaFleur.
Present.
Maureen Phillips.
Here.
Joe Topham.
Here.
All right. Staff, when I call your name, please respond in the affirmative. Jeff Carlson.
Here.
Joanne Dodd. Joanne, I don't know that we can hear you. Yeah, we don't have sound on you.
Reboot.
Yep. All right. So anticipated speakers on the agenda, please respond in the affirmative. So we have Bob Felch.
Here.
Dwight Dunk.
Here.
Josh Posner.
I'm here.
Okay. George Pucci.
Yes, I'm here. Good evening.
Good evening. Libby Gibson.
Here.
Stephen Cohen.
Here.
And Glenn Wood.
Here. Thank you.
I think we might have a few more jumping on, but they'll come in shortly. So good evening. This open meeting of the Nantucket Conservation Commission is being conducted remotely, consistent with Governor Baker's executive order of March 12, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, we have been advised and directed by the Commonwealth to suspend public gatherings. And as such, the governor's order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location. Further, all members of public bodies are allowed and encouraged to participate remotely. The order, which you can find posted with the agenda materials for this meeting, allows public bodies to meet entirely remotely, so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. For this meeting of the Nantucket Conservation Commission, we are convening by video conference via Zoom app as posted on the town's website, identifying how the public may join. Please note that this meeting is being recorded and that all attendees are participating by video conference. Accordingly, please be aware that other folks may be able to see you and to take care not to screen share your computer. Anything that you broadcast may be captured by the recording. All supporting materials that have been provided members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless I note otherwise. We are now turning to the first item on the agenda. Before we do so, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I will introduce each speaker on the agenda. After they have concluded their remarks, the chair will go down the line of members, inviting each by name to provide any comments, questions, or motions. Please hold until your name is called. Further, please remember to mute your phone or your computer when you are not speaking. Please remember to speak clearly and in a way that helps generate accurate minutes. For any response, please wait until the chair yields the floor to you and state your name before speaking. If members wish to engage in a conversation with other members, please do so through the chair, taking care to identify yourself. And for items with public comment, after members have spoken, the chair will afford public comment as follows. Staff will activate the chat feature on YouTube. Members of the public who have comments or questions can use this feature to communicate with the public body. Instructions are on the town's website. The chair and/or staff will do their best to address questions and comments. And then finally, each vote taken in this meeting will be conducted by roll call vote. So in addition to that, I do just want to remind everybody on the call and members of the public that might be trying to comment that this meeting is a Conservation Commission meeting and our comments and questions should be focused on Conservation Commission issues and jurisdiction. I will try and remind you if you start to go off track. So with that, we will begin the public meeting with an update or pre-proposal discussion. This discussion is about or presented by Sconset Beach Preservation Fund. Oh goodness. 59 through 119 Baxter Road. And I am hoping that George Pucci from Town Council can give a brief update or explanation of the process that's occurred, just to catch conservation commissioners up to what's been going on. So George, I'll give it over to you.
Great. Good evening, Madam Chair and members of the commission. George Pucci from Town Council's office. It's good to see you tonight. We haven't met for a while. You will recall on the litigation involving the denial decision on the SPPF expansion proposal. We had a brief meeting in executive session where I updated you as to the status of litigation and also advised you of a select board communication with SBPF of possibly having not settlement negotiations per se, but some type of getting a dialogue together with SBPF as to whether some alternative proposals could be pursued that might get to both resolving the litigation, but more importantly, see if there was a win-win situation that the town could reach with SBPF that would also accommodate neighboring property owners, especially down drift areas of this project proposal. The commission voted to have the chair, Ashley, be the representative of the commission in that dialogue with SBPF and a representative of the select board. The other members who took part in that dialogue were members of SBPF, as well as Jeff Carlson and Libby Gibson. Also, Ken Beaugrand took part in those discussions, as well as Matt Fee on behalf of the select board. I should note this was not an effort to reach any type of new permitting decision that would have to come from the Conservation Commission. It was only an effort between the select board and SBPF to see if there was a good faith possibility of some type of resolution instead of having everything resolved by litigation. And Ashley's caution to everybody is well taken by me as well. And you know, what the desire is to have as substantive of a discussion on the project proposal, the concept that's being presented to you, and have a substantive discussion on that rather than getting into extraneous issues and procedures and that type of thing. But just to update you briefly as to the context that I come to you before. And as you know, I've been representing the Conservation Commission since 2010, and we've enjoyed a very mutually successful relationship with respect to any type of litigation in which the commission has been involved. So you know me, and you know we try to err on the side of you know, public transparency. So we're not going to do something. We're not going to do something that, you know, would violate the open meeting law or have some type of secret negotiation or something, you know, beyond the jurisdiction of whatever board is involved. So the purpose of that working group was to explore this ongoing relationship between SBPF and the select board, and to see if a concept could be presented that stood a good faith chance of possibly obtaining a favorable permit from the Conservation Commission, assuming a new notice of intent on a new project proposal. And again, not to get too much into issues not within your jurisdiction, but for you to understand the perspective that the select board comes from. They have obviously different issues within their jurisdiction and their policy concerns that go beyond your jurisdiction. It doesn't mean that those issues are more important, certainly, than your environmental jurisdiction, but they're different issues, and they're also legitimate issues that the select board tries to pursue on behalf of the town. And basically, the long and the short of the existing relationship between SBPF and the town, the select board, goes back to the winter of 2013 to 2014, when the town's engineering consultant had confirmed at the time that there was a potential catastrophic breach in the area of the, you know, the existing proposal, the existing project that's now out there. So, you know, everybody knows the history of what went on following that, but the long and the short of it is a project ended up getting built at 87 to 105 Baxter Road. That was permitted by Mass DEP first, and then reconsidered by the commission with some tweaks to the project, and the commission entered into an order approving that project. SBPF, other than seeking, you know, permitting from the commission within the commission's jurisdiction, SBPF had ongoing obligations with the select board and the town. And what the select board tried to achieve is town, you know, interests and concerns being addressed by this project. So it was truly and still is, a public-private partnership where SBPF is bearing the burden of the cost of this existing project and some related very important ancillary issues. So following the permitting of the project at 87 to 105 Baxter Road, SBPF took on the lion's share of negotiating with property owners in the area of 87 to 122 Baxter Road, an alternative access agreement to the north end of Baxter Road in the event the project failed and there was a breach. They negotiated the betterments amounts and the property owners, the amount of the taking awards that would be necessary to relocate the roadway in the event of a breach in that area. And the property owners who signed off on that agreement agreed to give a one big beach easement, which those ended up being conveyed and recorded. And they also agreed that the cost of relocation of the roadway in the event of a breach would be paid for by the town by betterment assessments, and that the awards for the takings necessary for the relocation of the roadway would also be subject to betterment assessments. And those property owners agreed not to, property owners benefited by the relocation of the roadway, agreed not to contest the amount of the betterments necessary to relocate that roadway. So that agreement is, and that's not a small order of business. There were a number of property owners and sophisticated owners that SBPF was able to successfully negotiate with, including the trust for the lighthouse, the golf course property, and those property owners in the area. So that agreement is in full force and effect. However, that agreement is contingent on relocating the roadway in that area as a quote unquote last resort. So it's contingent on the town taking all steps reasonably necessary, but within applicable regulatory requirements, that the road can no longer be saved, and therefore you have to go forward with that alternative access roadway. The other thing that occurred as a result of that process is there is a shovel-ready project in place that SBPF had funded for the engineering studies necessary to, go right away with that project in the event it becomes necessary. So that brings us up to date. And the other thing that SBPF committed to, and a number of other things, but another thing that they had committed to when they received their permit for this 87 to 105 Baxter Road project was that they would not seek permitting for an expanded project until 2018. And they honored that. They went through that process with the commission, and they ended up with a 4-3 denial decision of the commission denying the expansion proposal. Litigation resulted as a result of that, and the select board authorized town council to litigate on behalf of the commission, both to defend the denial decision in Nantucket Superior Court, and also to file a appeal on behalf of the commission to the Mass DEP Office of Appeals and Dispute Resolution, appealing the superseding order issued by Mass DEP. The select board, by entering into this dialogue with SBPF, has not in any way changed their mind about that. The council is still fully authorized and to litigate on behalf of the commission and seek to have that denial decision upheld in court, and also to pursue the Mass DEP appeal, which has stayed pending resolution of the Superior Court local bylaw decision. So they have not changed in any way about that. They're in no way trying to replace your permitting decision. They're just trying to explore a win-win for the town from their perspective. And again, for issues within their jurisdiction and their policy concerns. And they recognize and respect that you're the first line of defense on behalf of the town of Nantucket for wetland issues out at Sconset Bluff. So your jurisdiction is fully intact, and there's no attack toward that as a result of these discussions. The only reason I give you the history a little bit is to just confirm to you that there is a very positive, there's been a lot of positive benefit as a result of this relationship between the select board and SBPF. And so that's the context by which they started this dialogue. So tonight, hopefully I'm going to talk little or no from here on, unless you have questions along the way. The purpose of tonight was, number one, to get out to the public domain as soon as possible the substantive discussions that occurred as a result of that working group process, so that the public can start to see what's being discussed, and they have the ability to comment on it to you as well. And also to bring to you what the result of that was, and get a substantive conversation between you and SBPF directly. One thing I did not, I recommended against for the town to do would be to any type of, going back and forth with you, the commission, the full commission in executive session to check things outside of the public. We've kept you out of the process purposely so that once there was a reasonably final new concept developed by the working group, you could be the one to have the substantive discussion directly with SBPF. So this is similar, forget about litigation and forget about the context of this. It's similar to any commission in the Commonwealth where an applicant or a prospective applicant with a big high impact project has some preliminary discussions directly with a commission at a public meeting or with an agent to try to get a sense of the commission's feel for that project, to see number one, what can they do to better improve that project that it might get a positive order, or in the alternative, get a real sense from the commission that it's a non-starter to begin with, and don't waste the time and the effort on going forward with formal permitting. So that's the purpose of tonight, for them to present this concept to you, for you to answer questions back and forth and take it from there. And again, it doesn't affect the litigation. It doesn't affect your ability to then rule on a permit in the event that a permit application then goes forward. It's just a preliminary meeting with an applicant or a prospective applicant that you would afford to any prospective applicant if they had requested it. So that's why we're here before you tonight. And that's a mouthful, but if you have any questions or comments, I'm happy to answer them.
Thank you, George. I appreciate you summarizing everything so well for everybody. So I just want to clarify my role in this a little bit. As George mentioned, the commission did authorize me to be part of the select board dialogue a few months back. I've been participating in that dialogue since you guys authorized me to do so. And my role in participating was to advise the group as best possible how this project could be curtailed to compromise with some of the Conservation Commission issues. So the work group memo that went around, you can see some of the changes that were made to the project to, again, try and come to more of a compromise with the commission. So me signing on in no way is like penning my support, but it is just identifying me as a participant in this process. And we did all work, together and positively to try and, come to this document. So that was my role. And I'm hoping Jeff can just clarify a little bit his role in this process. Oh, we don't have sound, Jeff. Oh, so he might need to get headphones out for a mic. So we'll just give him a minute. We still don't have sound.
Ashley, may I just add, while we're waiting for Jeff's sound, just the one last thing to emphasize. Tonight is not a hearing. It's a publicly noticed discussion. The public should know and they probably already know, but they should be reassured this would not be their only chance to comment on this project. If the dialogue is constructive with the commission tonight, and SBPF thinks it's worthwhile to proceed with a permit application on the revised project concept, there would be a full public hearing as well. So I just want everybody to rest assured, because this is a very difficult, format to hear complex issues, remotely. So, I just want to be clear about that this is not the only chance to comment and have your, say your piece about this project. It's mainly to get a sense from the commission about what their feeling is on the concept, and to see if it's worth it, just to give SBPF kind of a sense of whether it's worthwhile to go forward with a permitting application on it.
Yes, thank you for stating that, George, because I know that the public wants to participate in this process and has been confused by
Hello.
this meeting. Hi, Jeff.
All right. Sorry about that. Sorry to interrupt.
Nope,
Please finish.
you can go for it. I was basically done.
All right. Sorry about that. My microphone decided to sporadically work there without letting me know that it was going to work. So just to clarify, my role in the situation, it's very similar to any project really is in any of these groups or with any applicant or application. My role as the agent and administrator of the Concom is to provide, insight kind of a technical review to applicants, and is very similar in this case. I probably actually have, pre-application meetings with about 2/3 to 3/4 of the applications that come in before they're even filed as notices of intent. So this isn't really something too abnormal to sit down and have applicants provide information or do review to put their best foot forward to the commission. And that's the same kind of information and review I provided to the groups in this case, and a little bit of technical expertise for putting stuff together. So again, it's the same service that we offer anyone that wants to come in or has a thought to apply. In some bigger cases, I know we've talked about, coming before the commission for a pre-application meeting in front of the whole board. And that's what we're hoping to accomplish tonight. So again, by me signing on, it's more signing on that I participated and provided some level of technical review and, kind of review some of the concepts involved, understanding that anything that gets moved forward or concepts that are discussed are still, to face the full potential of a notice of intent and third-party review and additional scrutiny by the board and the public. But these are concepts that seem to be changes from the proposal that did not receive a favorable permit. So that was kind of my place. And again, I'm happy to answer any questions about of my participation or anything that happened in the process.
Thank you, Jeff. We also have Matt Fee and Libby Gibson here. I don't know if you guys want to speak to your role or if you're happy just being on the call at this point.
I'm happy just being on the call at this point and could potentially answer any town admin related questions.
Thank you.
Yeah, I'll say something real quick. I think George Pucci did a good job. The goal was to explore whether there was a compromise path forward that worked for the Concom, the town, the public, and SBPF. I wanted to avoid the uncertainty of litigation or administrative hearings. I think I've found from my own personal experience, the only people who benefit the most there are the lawyers. No offense to the 2 or 3 lawyers in the room. The working group trying to find a fair middle ground. And I think we did. I think everyone's a bit unhappy. So hopefully, we'll be close and you guys will figure that out. The compromise won't cost the town more money. Continued divisiveness will do that. Legal bills, maintaining the current project if PBF abandons it and the town needs to keep it in place, as well as all the staff time and effort will cost more money than if we can find a compromise. I hope we do. I was the swing vote on the select board the first go round, and the road was threatened. Rocks seemed as though they might be approved in Boston at that time. So I supported a scaled down project with the geotubes, along with an escrow account to have them removed if that was needed. We've had years to study and look at the impacts, and we've done that. And I'm not saying it'll last forever. And the work group didn't say that the current project will last forever. Some feel it will do harm sooner. Some feel it might come, but only later. And an important point is what we did agree on was that we need fair, clear criteria and improved oversight. So when the day does come that it is causing harm, it is corrected or removed. And again, that wouldn't be at taxpayer expense. The work group and the select board, George covered this. We're not here to tell the Concom what to do. The Concom has a key role to play, and we're careful we were really careful to respect that, as Ashley said, and Jeff. I hope that the framework provided and the revisions and clarifications successfully address the concerns that was raised when the project was denied. But that's up to you guys. That's, I'm not saying that. I'm probably naive. I've been called naive before, but I hope an honest, respectful conversation can lead to a project that makes sense, is approvable, and can move forward. The job of the select board is different from the Concom. As George said earlier, we have, there's our decision making. Some of the things we've had to do are based on previous agreements that and we are doing our best, but we're also supporting you guys. You have to know that. The select board need to think about broader issues things like, can we protect the access to Baxter Road in the lighthouse? Does the town have the financial operational ability to reconfigure Baxter Road with all that entails? Takings and, the state law hasn't caught up with sea level rise, et cetera. There's a lot of things there that are very complicated that go into our decisions that you guys may not have to worry about. Can we, alongside the Concom, ensure there are clear criteria for enforcement and potentially removal that stand up to a legal challenge if this stops working? That's another thing we worry about. Can we build an island-wide plan for coastal resiliency that makes sense for the different parts of the island? We've just started that process. That's, a big issue. Can we get the sand needed for this and an increasing number of other coastal projects in a better way, than a ton of trucks up and down the road and digging out the middle of the island? Again, that's not in your purview, but we have heard that loud and clear from the public and have made some efforts in this to do that. The offshore sand idea is potentially a really good thing. I know there's a lot of hurdles to that, and it won't happen right away, and maybe it never will. But as the sea level rise and resiliency adaptations, they're going to require a lot of sand. Where are we going to get it? How are we going to afford it? We discussed that. You'll hear some of that probably when you guys are working on it. And the other thing is, I look at this as I don't look at it as us and them. I look at this, we're all friends and neighbors here. Even if we don't get along, we have to get along, And I look and say, if these guys can protect their homes while doing no harm to others, I think we should let them do that and put aside the bickering long enough to listen closely to each other and find a solution. I've met regularly with people on both sides of the issue. I've asked everybody to tone down the rhetoric. We've been trying to thread a admittedly small-eyed needle. Sheila will be happy to, I had a knitting or sewing comment, and I hope we do so and take this chance to tighten and clarify the conditions and move forward, addressing legitimate concerns of both sides. I think that's the, sort of my hope on this, and we'll see how it goes. Thank you.
Thank you, Matt. And commissioners, if you have a question at any point, just raise your hand and I'll, allow you to ask your question as we're moving through each kind of group of people. Maureen?
Madam Chair, I don't have a question, but I have well, it might be a question, but it's more of a comment. Would that be appropriate now?
Yes.
Okay. I guess the not having been aware of the exact charge of this group, and that this was put together to try and apparently bring together a new and better settlement that would be, as people say, a win-win for all sides. So I was pretty surprised when I saw this, and a lot of my surprise was because it had been my clear impression that we were, in the midst of litigation, that we were waiting for the Superior Court decision to come down, that that waiting, just so people are clear, the being in Superior Court where they're working on the existing record. This isn't like we have a trial to go through now, or witnesses or evidence or anything like that. The judge is just looking at the written record, which was presented by the party to the judge, so that the concern about additional expenses about litigation, I was surprised to hear that, because I don't think that we're looking at a lot of expense for continuing the litigation through a decision by the Superior Court, but also as I like to think of myself as a recovering lawyer, that I had always understood that a decision by a group like the Conservation Commission, the standard for the applicant to prevail at the Superior Court would be for the Superior Court to hold that the action taken by the Conservation Commission was not reasonably related, reasonably being the underlined word, to the preservation and protection of the interests protected by the bylaw. And that they must show that our order was arbitrary and capricious, meaning that things were kind of pulled out of the air and decisions made in that way. And one case even said that the fact that the plaintiff's expert did not believe that the conditions put together by the Conservation Commission, that alone doesn't demonstrate arbitrariness or capricious behavior. So with all that in mind, and knowing the hundreds, if not thousands of pages of this record and all the time that has been taken since the original application in 2013, and decisions back and forth and the rest of it, I believe that our position at the Superior Court is quite a good one. And so, I was, waiting for that to come along. So I was quite surprised to see such an effort put together by the applicant in order to take the current litigation, where I believe we're in a very strong position, and exchange it for what will essentially would become really a settlement agreement. And it's also, and I find that just odd as a lawyer. When I was negotiating agreements like this, I found that it was the party who believed they had the weaker position typically is the first one to raise the idea of having a settlement discussion because they don't want to go forward with the action. And they believe they would do better to step back and try and negotiate with the other party. And but this puts us, I think, in a really strange situation because I think we have a winning argument, and this would wind up having the Conservation Commission essentially negotiating with itself, and which I don't think makes sense. And also the thing that looking at the process of this, I've got two more comments, and then I'll be done. One is that the impact on the environment has been absent from these discussions. The word environment, I've listened to the whole select board meeting and going through the papers we have here, and the resource areas that we have sworn to uphold their protection are not mentioned. What is mentioned is the interests of the town, a relationship with the SBPF, the private ownership of a number of homes, but I am not hearing any explicit concern about the interests that it is our task to protect. And further, the makeup of the working group was heavily weighted to provide to that working group a position that would be where there were many highly paid and certainly very sophisticated people involved on behalf of the SBPF on that working group. And we have a volunteer who has a full-time job, and we have a town employee who is like all in town employees since COVID, has been trying to do 6 jobs at once. So it seemed to me that the environment did not have representation. I understand the town did, but the environment did not have adequate representation on this group. To me, it makes, I can, like, if we had been approached with a real settlement offer in the way that is typically done when there's litigation, ongoing litigation, I mean, that would be one thing. But there was no independent expert on this group. We finally received the latest annual report from the SBPF, and that has been examined every year by a independent consultant, which has been Greg Berman from the Woods Hole Institute. We have not, I don't know if he's seen it yet, let alone provided us with an opinion on that. So we are at a situation where I do not feel, the content of this is one thing, but the concept of how it came about, the lack of balance on the group, and the failure to have any kind of independent expert opinion on what has been proposed is, I mean, I am surprised is probably my most significant reaction to this. And again, I think we're in a good position, so I'm not sure why we would want to go after this particular set of proposals, given the situation, given the group of people who put them together, and given the fact that the environment is not at the top of the list of important issues that have to be addressed. That's our jurisdiction, and it's not and that's what we need to think about, and that's what we did think about when my predecessors on this commission gave their opinion last year. And it's what this commission has thought about when we have had to issue enforcement orders against the SBPF for failure to follow the existing order of conditions. So it just, I find myself, surprised and stunned and disappointed, I think, as well. So thank you.
Thank you, Maureen, for letting us hear your perspective. I think the idea behind tonight's discussion is to allow that environmental piece to be heard, so that all commissioners can ask questions of SBPF, and they'll have a chance to hopefully present their project here shortly. And we can really get it all out on the table, because, me as the one representative from Concom on the working group, it's not possible for me to represent all 7 individuals of the Concom. So that is why we're here tonight, so that all of the commissioners can express concerns or approval, whichever way they feel. So thank you for that. Joe?
Yeah, I heard from Matt twice. I heard him in the select board meeting and tonight that, he didn't want to step on our toes. He basically, worked within their circle. And, once they kind of defined their role and, the work group went forward, I think that they said, all right, well, we've gone as far as we can. Now we're going to push it off to the Concom. Now it's in their, ring. And I think that that's been fine. I'm not surprised because we did say to you, please go represent the Concom. And I think you've done an excellent job. So thank you. So yeah, I'm not surprised by the letter coming back. I was in favor back, when the vote went down 4-3, and this was voted down to see if we could make it smaller. And so I'm kind of happier that, the DEP came back with something really positive and more within what I think is palatable. And I think that there's a town as well has negotiated and worked with the SPPF group. There's 5 local town officials there and against 4, SPPF. I think that that's a positive thing. Just sit down and have a discussion before it gets too far. And again, I agree with Matt. I've always thought this, for any application, it's not about the property owner. It's about the property. It's about the wetland that is attached to that property. And so we just need to not make it personal and let's just look at the rules and regs of the state and local and then make our actions and decisions based on that. And I really think that would be a wise decision moving forward. So however this goes forward, I just think we all just kind of need to have that perspective and really be careful in our words going forward. But yeah, again, I'm not surprised. I mean, Ian and Ashley, you both went into the first meeting and then George said there was kind of a little bit of conflict. So just one representative. So we did want more, but we were only allowed one person at the table. So I'm fine with everything you've represented for us, Ashley. So thank you.
Thank you, Joe. Looks like Seth has a comment or question, and then Ian.
Thank you, Madam Chair. I know that most of tonight is going to be based on the content of the letter, so I'll just make this very brief in terms of one comment I have about the process. I voted to allow you to represent us, and I am glad that the town and SPPF are coming to the table to see ways or to evaluate ways that may be possible for permitting to proceed. I don't think that anything that's happened so far is requiring the commission to vote a certain way. It just some people sitting at a table putting thoughts together. I do sort of contest, however, to the idea that what's happened in the past is being represented as bickering or divisive. I think the Conservation Commission followed a very standard protocol that's well-backed legal protocol that happens not with this project only, but with many projects. Many projects receive a denial and then are appealed through Mass DEP on the Wetlands Protection Act through the state and in Superior Court on the local regulations. I know that litigation can be costly and can be time intensive. I personally have no issue with allowing the process as exists right now with the current litigation to sort of just proceed. But I'm happy to hear why the SPPF representatives think what happened in the working group changes what's already happened previously. So I hope this isn't meant to be divisive. This is meant to be, a decision on very technical performance standards. If people in the community feel this process has been divisive, I wasn't on the Conservation Commission when the last NOI was submitted, but I think that those are personal feelings rather than anything kind of that's happened with the process. The process is very standard. Thank you.
Thank you, Seth, for clarifying that about the process, because I would agree the Conservation Commission doesn't act in a divisive way. We are very meticulous in following our process of every notice of intent, so it doesn't matter the applicant. I think we're very thorough, and that's something our commission should be proud of. Ian had a comment, and then Matt.
Well, Madam Chair, I think Seth and Maureen have largely covered it, Seth in particular. And it does seem as though 10 months of exhaustive hearings are going to be compressed into one meeting. And I'll reserve any comments until later. Thank you.
Thank you, Ian. Matt, you have a comment?
Just a quick clarification. My comment on divisiveness isn't targeted toward you. I can assure you the amount of emails, and some of them pretty nasty from either side, that the select board have received for 10 years, and if you read some of the stuff in the newspaper, I think that's what I'm talking about. I wasn't referring to you guys at all.
Thank you, Matt.
And I agree. That was my comment as well. It was the 7 that voted down this project did an outstanding job, exemplary job, and I think that we'll do the same. So I'm not worried about that. Thank you.
Thank you, Joe. Bob Felch, it looked like you had a comment.
I had a 20-minute presentation, which I'll shrink down to 3 minutes. I was planning to follow. Thank you, Madam Chair. And my name is Bob Felch, and I live in the village of Sconset, just off of Main Street. And my plan was to follow Matt with comments. A little bit about my history. I've spent the last 30 years involved with local nonprofits, and for about 13 years of that time, early in the this century, I was the head of the Sconset Trust. I was the board president and then the executive director. And during that time, I was charged with figuring out how to move Sankaty Lighthouse away from the bluff edge to a safe place. And it was a rather remarkable feat. The technology was not very complex, but the project was engaging of our community. In fact, at the time, I mentioned to the other Josh at the Inc and M, Josh Balling, that the effort was, it takes an island, and it certainly did. People from Nantucket to Wellwinnet were engaged in the effort to support the move financially and also as volunteers. So during my years at the Trust, there wasn't a day that went by without me thinking about the eroding beach, the toe of the bluff, the top of the bluff, all the houses on the edge of the bluff, Baxter Road, even the houses on the land side of the bluff. And of course, importantly to me, access to the lighthouse. We spent a great deal of money making the lighthouse property accessible to all people. But the thought of Baxter Road being in peril and eventually unusable was certainly disturbing to me. So I just want to make one clarifying point, and I know George didn't intend to include me in the SBPF group, but I am not a member of the SBPF group, nor have I ever been. I have been a voice for the Sconset Trust and a citizen of Sconset. I was very deeply engaged in the alternative access negotiations, and it's possible my name is on that agreement. I don't remember signing it, but I think I might have. And so I've been engaged. And really the points I want to make is that I joined the work group at the invitation of Matt Fee, really to be a different voice, a voice of perhaps a neutral voice, maybe a quieter voice from Sconset, who you might not see that I'm a stakeholder, but as a citizen of Sconset, I feel that I am. So nobody's ever accused me of being an activist, but I am a concerned citizen and somebody who has some history here. So this memorandum that came out of the work group is simply a framework for working to a solution that contemplates compromise, collaboration, and coordination. These elements relate to the design, the functionality, the management, and importantly, the monitoring of a protection system. And you all know that better than I do. The new approach and this phased methodology are certainly worthwhile CONCOM giving new consideration to, in my opinion. And CONCOM, of course, is the proper regulatory body to do this review. So I don't make the call, you do. I would reiterate a comment I made in an article that appeared in today's paper under my name. And if you haven't seen it, I would encourage you to read it. It's not a masterpiece, but it really gives my sort of broad perspective about erosion on Nantucket, not just Sconset. And in that, I said that CONCOM is the gatekeeper, period. End of discussion. So I think that I'm appealing to the 7 commissioners to really give us their ear, to help review this, to give us direction on a way forward, and open your commission to receiving a new NOI. I do think it's quite different, and I can't respond to Maureen's very articulate and compelling comments, but I think it's worth a revisit. So we did receive professional input from you, Madam Chair, during the meeting, but in no way did you ever come out and support what we were proposing. You basically gave us guidance, professional guidance, and we appreciate that. So I think the Sconset Bluff is about as high profile as you can get on this island in the erosion world. It is certainly what we might call ground zero today, but there are going to be many other communities at risk. You all know that there are 78, I counted on GIS, primary residential structures on the full span of Baxter from north to south. They are all at risk, and they're all at risk in the near-term future. So it's not just a few houses up at the north end on the bluff edge. So I encourage you, and I just want us all to be receptive to a new NOI application from CONCOM. Thank you very much.
Thank you. Dwight, do you want to speak about some of the technical changes?
Yes.
Or proposed changes?
Thank you, Madam Chair and members of the commission. I just have a few comments following, the introductions by others. First, I just want to give a brief summary of the framework, the main elements. These are not necessarily in order of how they're presented in the report or memo, but the elements that the working group try to address and cover in the working group report. It addresses sustainable sand and funding sources. It improves public access. The framework augments the monitoring program. It clarifies failure criteria and protections, establishes the legal compliance for the proposed project, proposes a phase construction, concurs that all the structures and lots qualify under the bylaw for protection by a CES, confirms no alteration of coastal dune for the expansion project, adjusts the design length consistent with the DEP, established for the technical established by the DEP, and establishes technical criteria for southward extension, again, but ensuring no coastal dune alteration. Addresses sand mitigation in clearer terms. Template cover, contribution sand with volumes broken down into sections or reaches instead of just a length weighted average. Seeks to identify and use offshore sand for a long-term source of sand, and with that offshore sand, develop basically a sandbank that could be used for other projects on the island. As has been mentioned with resiliency projects, a lot of sand is likely going to be needed going forward for resiliency projects. I'll get into a little bit more on the technical aspects. Now I just wanted to kind of go over those bigger picture elements. In terms of the responses to comments, we know that there have been written responses, comments submitted to the Conservation Commission verbally at the Select Board. We prepared and submitted a written response that's in the record. We're not going to go over that tonight, but we also want to point out that one item relating to the Green Hill family attorney's letter that was answered separately. As I think Matt and George and others have tried to identify, the working group really focused on clarifying items in the DEP superseding order of conditions, addressing the bylaw, and as we understood, trying to address the few technical and regulatory details that led to the denial of the OOC, so that we might be able to develop some revisions to the project that would result in a favorable order of conditions. The existing project, 950 feet, round numbers, that has been successful in protecting the bluff from erosion for 7 years without harm to the neighboring beaches, the fronting beach or the abutting beaches. It is meeting the interests of the Act of storm damage prevention, protecting Baxter Road and the houses along that section of the bluff. And as a pilot project, thinking of it that way, it documents the efficacy of the geotube design with the template management replanting of the bluff. The monitoring that has been going on for many years shows that the fronting beach and the abutting beaches to the north and south have shown no harm from the project, and it's been fairly stable over this period of time as measured by the position of the mean low water line, and variations in the beach are essentially seasonal annual variations that we see up and down the coast, the east coast of Nantucket. But this project is proposed because there is a long-term trend of coastal erosion from north to south. So with that, those kind of bigger picture comments, I just want to discuss a summary of the revised proposal. As was mentioned, the proposal is would be to construct the extension in phases, with holding off the southern 900 feet, which protects the last 7 homes along this reach until later. Phase 1 would be from the existing project north to protect those 3 houses up to that include up to 117, and then south from the existing project down to 71 Baxter Road at about Bayberry Lane. Phase 2 would be 71 Baxter to 63 Baxter. This phase would be delayed until the long-term sand source is permitted and secured. This is this phase matches the DEP superseding order of conditions. Phase 3 would extend south from 53 Baxter to a point where erosion has advanced, is defined as a permanent loss of coastal dune and seeing damage to the coastal bank based on objective criteria. And that would, as we had tried to identify, that would occur in the future when those conditions are identified. Another component is how to manage the template. As we all know, the template is the on-site sand storage, sand stockpile. That sand is used to recover exposed geotubes after erosion events. The sand on the front face of the geotube is that sand that's readily available to be washed off into the littoral system during storm events. And then the on-site stockpile is used to recover it. But one thing that, Ashley suggested was looking at this template differently. We have been looking at it as a one size fits all with a length weighted average amount of sand across the entire length. But the bluff has variations in the contribution of sand off the bluff to the littoral system. So what this does is this means that this approach would more closely match how the bluff responds to storm events and the contribution off the bluff to the system. So it's, I think, a more nuanced than the single, one size fits all. We've identified 4 reaches, as I call them. You can think of our segments. Reach 1 is the area of the bluff north of the existing project. That area of the bluff is oversteepened. It's exposed sand, and is eroding. There seems to be some more clay content in that reach, so we don't have quite the same retreat rate as we have in Reach 2. Reach 2 is the existing project plus 85 Baxter Road. So much of Reach 2 is already built. At 87 to 105, that area is stable. As I said, the geosystem has done its job with the stabilizing that coastal bank and providing the interest of storm damage prevention. But on 85, the bluff face is oversteepened and exposed. The removal of the material from the old house shows that that bluff section is continuing to erode. The calculated sand volumes off of that reach, on this reach, is about equal to the average annual volume that's contributed off the template for the past 7 years. And that rate is working because we see the beach in front of the geotubes and abutting beaches remaining quite stable. Reach 3 is 83 to 75 Baxter Road. Here, along this reach, the toe of the bluff is exposed, and the slope of the bluff is eroding, showing signs of slope failure and sloughing, meaning that toe erosion is telegraphing up the slope and we're seeing retreat at the top of the bluff also. Reach 4, which is south of 71 Baxter Road down to 63, we're seeing toe erosion. We're seeing some initial signs of slope erosion and failure, but the sloughing and failure has not been telegraphed up to the top of the bluff yet. The top, we haven't seen retreat at the top, but only at the toe. But as we know, the process starts at the toe and works its way up. The mitigation sand volumes presented are, using the methods, the formulas that have been vetted by the commission staff, by the peer reviewer, DEP, and CZM. And these are the standard DEP and CZM formula of volume for coastal bank mitigation, CES mitigation projects. What we did was use the same data that's been presented in the previous notice of intent, but we calculated it for each of the 4 separate reaches rather than averaging it across. And then the idea would then be to backfill each reach based on the calculated volume for that reach before each storm system. The monitoring, we have asked for a reduction in the frequency of monitoring for the shoreline monitoring that because of the results of the past 7 years. But we, certainly hear the working group in an effort to, develop consensus. The proposal includes quarterly shoreline monitoring continuing for 3 years after construction of each reach, semi-annual thereafter, provided there's no adverse effect in the fronting and abutting beaches. The guidance from DEP for beach nourishment projects, because in many respects, this is an indirect beach nourishment project. This exceeds the DEP guidance of 1 year of quarterly monitoring, or what they call seasonal monitoring, and then annual thereafter. And then Jeff had a very great pragmatic, common sense part of the monitoring, and that's, we're calling them grade stakes. They are essentially would be like more like a settling platform if folks are geotech are familiar with that. But what that would be is a visual measurement of the sand depth atop the template with one grade stake per reach. And that way it can easily be monitored in addition, in between the monitoring events. And it's, something that is very user-friendly, so to speak, to see what the depth of the sand is on top of the template, to know that there's enough there to continue to recover the exposed geotubes after events. So that's the kind of the technical overview. And just following up with what George and Matt have commented on, and Jeff too, this is essentially a pre-application meeting. This is a common occurrence with conservation commissions, and we're not seeking the commission to endorse the details now. This is not the right venue for that. Any decision, if there is to be one, would be through a future notice of review of future notice of intent in that public hearing process. We are prepared to, on behalf of the SBPF, to develop an NOI based on the framework if this proposal and this direction has merit, and there is interest in getting a project that might be able to be approved. So we're looking for your feedback, on these revisions proposed by the developed by the working group, and if the commission sees some advantages in this framework, we'd like to know whether or not an NOI based on this framework, has merits for review. So that's, really the technical piece, and what we're looking for. Well, not what we're looking for, but what we want to have a discussion on. And that concludes my comments, Madam Chair.
Thank you, Dwight. Does anybody else from your group have anything to add, or was that it for your presentation?
I think Stephen just wanted to make a few comments.
Okay.
I do, Madam Chair. So I want to somewhat address the points that Maureen made, although not so much as a rebuttal, as a recharacterization. And I think it's important for everyone to understand that this is not a meeting to discuss a settlement of the litigation, although I think everybody hopes that elimination of the litigation could happen, and that's generally viewed as a positive. As Dwight said, this is a pre-hearing meeting to discuss some points that he just went through. And what I think is important to understand is that when the Conservation Commission denied the last notice of intent, it was close. There was a lot of discussion among some of the commissioners that the proposal might not be approvable as presented, but that with some changes, it might be approvable. It wasn't a black and white, answer about, no, this could never happen in any conceivable way. And I think what this working group has really done is try to think about the project both in terms of Conservation Commission wetland regulations, but also in terms of public policy in a way that it would be able to both be an improvement under the wetland regs and also an improvement in terms of community impact. And so, if you sort of take a step back and listen to what Dwight went through in a technical way, the improvements that we see are that, there's better addressing of the sustainability and funding of the sand, that there's improved public access, that there's improved monitoring, that there's improved failure criteria and protections, that there's a breaking up of the construction process into phases, that there's a establishment of a legal compliance based on subsequent data that was gathered after the last NOI, and also based on criteria that are in the DEP superseding order of conditions that was issued after the NOI. So I think it's important to note that not only is there changes, but there's also legal determinations that were made by DEP that did not exist at the time of the Conservation Commission's order, that there were a number of questions or suppositions which have now been addressed. And so we were all able to take a view of this in light of the information in that superseding order. There's an assessment of the structures and the lots and their qualification under the law with those decisions. There's a confirmation and alteration of the design so that it's not impacting the dunes. There's an adjustment of the length and design and the hardness of the ends. There's a clear process for mitigation sand, different ways of calculating it that are more understandable and easier to track and implement. There's a better process for the template cover and assessing the bank height and volumes instead of trying to do it all as one big project. I think what we ended up with was a formula that had numbers in it that didn't make any sense to anybody because the project was so large. And I think that the idea that one of the best ideas that came up with this, that came out of this working group, was to break it up into sections that are more understandable. So I think what the commission should think of tonight is not whether or not enough changes have been made in order for the commission to settle a lawsuit. That's not the question that's in front of you. And it's not what was discussed, and it's not what's being asked. And it's not a matter of, are the changes in front of you approvable or not approvable, which is something that you should only really decide in a hearing in which that's the question in front of you. I think that what the commission should be thinking about, based on what Dwight presented, is, are the changes that were presented improvements that the commission would positively, view positively in a new NOI that was presented. So, and that's what we do in a pre-hearing discussion, is get some feedback from the commission on, if this comes in an NOI, what does the commission think about it? And that enables the applicant to then make some adjustments and improvements to its application so that they can come in with a better presented application. And I think that's the goal here, not to get some we know that there are going to be people both on the commission and in the public that are against this project or think that it's approvable or not approvable. And we know that there's some aspects of it that people will like or won't like, but that at the end of the day, what we're looking for here is feedback on the changes that are presented as a way to see if it seems like a more feasible and more approvable and preferred way of trying to deal with this project in an NOI that has not been designed or drafted or presented, but is in process. And I think that hopefully is a question that the commission will answer positively and will give us feedback on, even if some of that feedback is positive and some of that feedback is negative, which is what always happens in a pre-hearing review. Thank you.
Thank you, Stephen. So at this point, commissioners, I'll open it up for questions and comments. These will probably be directed more towards SBPF and some of the technical aspects of their proposal. I also want to just kind of remind everybody or make everybody aware, we also have individuals in the waiting room. So if you have questions for individuals who wrote in comments, we should be able to pull those individuals in to answer your questions. I don't know if that's very clear, but Jeff's shaking his head yes. So he might explain that more clearly. But if say you have a question for the land council, or I think Doug Rose wrote a letter, any of those people, if they're in the waiting room, we can pull them in. So at this point, are there any questions from commissioners or comments? Seth?
Thank you, Madam Chair. I have some comments related to the sand sourcing that's been proposed. I think having the idea of an offshore sand site is definitely beneficial. I think that needs to happen, however, before phase one rather than before phase two. I think what's being proposed by SVPF with a three-phase project, essentially, is something that's going to happen in succession, but it's, we need to know before moving forward with a proposal that would allow multiple phases of development, that sand source is going to be there, because already with the project that does exist, there has been concerns with the ability to source, first of all, enough, and secondly, clean mitigation sand. And I think with the process of enforcement actions that happens after the denial of the last notice of intent, it's become clear that not only do we need a clean, reliable sand source, we need enhanced characterization, or I guess parameters for allowing sand. So we need sand that not only meets a grain size, as has been applicable in the past project, but it also needs to meet a rigorous level of chemical, biological, and perhaps color testing. So I'd like to see all of those things be added to any type of sand sourcing or mitigation sand sourcing proposal that's put forth, so that we know from the start, if this project is permitted, that we're never going to have an issue with enforcement of mitigation sand in the future. We need that reliable sand source, and without that sand, essentially the project doesn't have any benefit. So I think that's crucial to have before anything is allowed to proceed.
Thank you, Seth. Dwight?
Madam Chair, I'd just like to comment that in looking at the phasing, the phase one section is the section that has sections of the road and homes that meet the imminent threat criteria established previously for the project. So I just wanted to, indicate that, because of those types of very short setbacks in some cases, that's why those were proposed for phase one. And, I'll just leave the comment there without going into the all those aspects, since that's not the role of tonight's meeting.
Thank you, Dwight. Any other comments or questions from commissioners about, again, the technical aspects of this project, or you can call in people who may be in the waiting room to ask questions of their comments. Okay. So it looks like there are no questions or comments from commissioners. Jeff, do we have public comment on the YouTube that might be valuable right now?
I know Sam Kefferstan from Mass Audubon said that he was going to be putting some comment into there. I hadn't specifically asked for it at this point, but I'm happy to do so.
Okay.
Or if you would like, you can take comment from folks in the waiting room as well, but that's up to the commission.
Yeah, I can't see the waiting room right now, so I can't see who might have their hands up.
So in the waiting room right now, and we can see people with their hands up, are Megan Perry, Bruce Perry, and Emily, RJ, and Trey from the Land Council.
Okay. Well, I guess we can see if they have comments or questions.
Do you want me to let them in?
Sure.
Got a little bomb onto the.
wait a moment for people to join in. Seth?
Yeah, sorry, I do have some other things, but I was hoping to give someone else a chance. I'll be quick while other people are joining from the public. I do think that there is a mischaracterization that's been presented related to all of the lots being, allowed to have coastal engineering structure. The superseding order of conditions that Mass DEP issued only addresses the state act. So we often don't necessarily see this, but our commission kind of enforces or has regulatory oversight over two different processes: the Massachusetts State Wetland Protection Act and the local regulations. So even if the structure is maybe allowable under the state act, we don't know if those same lots would be permitted to have a coastal engineering structure under the local regulations. And there's no way to know without us continuing the litigation in Superior Court. That decision, that hearing, is what will tell us if those lots are allowed to be protected or not. So if we don't have that hearing and we don't get an official position on that, we don't know that. It might be permissible under the state act, but it still might not be permissible under the local act.
Thank you, Seth. Ian?
Yes, Madam Chair. So following up on what Seth has said, without getting into the weeds, the existing geotubes protect 7 lots in total, of which 5 are vacant, which under our local regulations are not entitled to protection. And there's 2 pre-78 houses. And going north on the proposal for phase 1, there are 3 vacant lots and 2 vacant lots and 3 pre-78 houses. And then going south, of the 9 lots, 4 have more than 20% added to them. 1 is vacant and 2 are post-78. So out of the 9 lots, only 2 are pre-78 and entitled to protection under our local regulation. And so Mr. Felch, when he mentioned 78 houses in total on Baxter Road, I mean, first of all, even in the expanse that we're talking about, not a single house on the west side of Baxter Road is in our jurisdiction because they're well outside of the 100-foot line. And I guess, and I would disagree with Dwight about the no environmental damage and the storm between the 4th and 16th of March in 2018 just showed how much NSCAR there was, which was really significant, as well as how much loss of sand there was to the center of the beach. And the fact that out of the 22 cubic yards per linear foot, only about 7 cubic yards per linear foot are actually available on the front of the geotubes, and the rest is inaccessible. And so when Steve says, the nub of the issue are the changes and improvement, I would say no. And as Maureen has said, there's no really, that all the environmental issues that were carefully considered over 10 months are not really addressed. So thank you, Madam Chair.
Thank you, Ian. Any other comments or questions from commissioners at this point? Joe?
Through the chair to George Pucci. I thought that when we brought up the 20% rule back in our 10 months of going back and forth, I thought that he was saying that the state would override our 20% rule because it was enacted. I think, Jeff, if you can correct me, it was 2004 when that was brought into our bylaws. So I hear what Ian's saying, but I'm just, we hanging our hat on something that's not there to hang.
I'm referring specifically to our local regulations, Joseph.
No, I got that. And I just brought that up, but I think that if George is going to go forward and says that that's local, but the state's going to override that decision no matter what, because it was enacted in 2004. And I just want George to weigh in. Is that what he said back then, or I just want George to clarify that.
No, I think, and George can clarify, I think you're right, Joe. The state essentially has overruled us with their superseding order. So they have kind of said that, but I agree with Seth and Ian that, our local regs are different. So Superior Court might look at these lots differently, but George, maybe you can clarify better.
Hi. Yeah, what Joe had said was actually what the applicant had claimed. And you're right, everybody's right that the Superior Court case will decide the local bylaw decision. That they won't consider, or they shouldn't consider any override by Mass DP on the State Act. But Joe is saying basically what SBPF's position is on that. One thing I would recommend, I would leave it at that. I would recommend against, me giving you any legal opinions on, a case that I'm going to both brief and argue in the court on behalf of the commission. So I would try to stay away from, weighing the merits of the legal issues, and I would recommend focusing on more, the performance standard related issues and concerns that you have. And, I would remind you too, the local bylaw protects the roadway as well. But that was SBPF's claim, and they did put, they put together, I don't know if it was presented to the commission, and Ian called it the weeds, and I would recommend trying to stay out of the weeds at this point. But they put together a supplemental presentation about analyzing the project area kind of lot by lot and putting together their case, of why they feel the way they do. We did not engage in this process in a way that, we sought to convince them to our case or, show them that they're wrong on legal issues and that we're going to win in court. That wasn't the purpose of this process. The purpose was to have a productive discussion about, how they might tweak the project to get a favorable vote, possibly, and to put that for you as soon as possible. But we didn't engage in any process where we had expert analysis of what they were providing, and we certainly didn't get into legal issues. There was not argument amongst the lawyers as to who's going to prevail in the Superior Court case. I was not part of this at all. And I would definitely recommend that the commission stay away from that dialogue in open session. And I'm certainly more than happy to meet with the commission in executive session to discuss strategy with respect to pending litigation and the strengths of the commission's case and answer any questions with respect to that in that context. But with pending litigation, I would recommend strongly against seeking any type of town council opinion concerning issues that the court may well have to rule on.
Thank you, George.
Yeah, I'm sorry, I didn't mean him to show us his cards.
No, you didn't. It's not. No, it's a great question, and
Yeah.
and there's a fine line between having a discussion with the applicant about the merits or unfavorable aspects of their project. There's a fine line between getting into that and trying to convince each other of who's going to win in court. But to the extent you can stay away from those issues, the better off you are, because you just don't want to have that dialogue in public. I mean, I'm happy to, advocate on behalf of the commission as to why it's a slam dunk in Superior Court, but it's not appropriate and it's not helpful.
Okay.
And and again, I'm certainly available to meet with in executive session where that dialogue could take place.
Yeah, and I mean, we don't want to go cherry picking from one to the other. We want to be really clear about staying in the state lanes and the local lanes. So,
yeah, and the thing is I have to say, this is why the substance really of the presentation is what's before you. If Ian just articulated a very reasoned view of his take on this, and so if that's if it ends up being the consensus of the commission that this is really a non-starter, SBPF is good to know that's the whole purpose of this. So you should, while I'm recommending against me opining on legal issues that would be decided by the Superior Court, that doesn't take away your ability to say, no, we're right on this. And, we don't see anything that improved it or changed our view on it. That would certainly be appropriate. And it gives the applicant a read that, whether or not it's worthwhile for them to continue pursuing this.
thank you, George.
Thank you, George. So Mark's had a comment for a while, and then Ian, and then Maureen.
Yes, thank you, Madam Chair. I'm reluctant to move ahead with this process with the Superior Court case still hanging. It was, thousands or hundreds of pages of documentation on that decision, and I'm not sure it's up to us right now to say, let's regroup and do it in 3 phases. A similar type project may not be exactly the same, but I think out of respect for that decision, I would be in favor of letting Superior Court play out and see what happens there and then proceed from there. Thank you, Madam Chair.
Thank you, Mark. Ian, you had a comment or question, and then Maureen. Oh, you're muted, Ian.
Sorry. So thank you, George, for your advice as always. And actually the road is outside our jurisdiction because it's outside of 100 feet up until lot 81. So it's only within our jurisdiction from lot 81 forward. And I agree with Mark. So thank you.
Thank you, Ian. Maureen?
Yeah, my comment was to tell George that I would like to very much accept his offer for us to have an executive session with him as soon as possible. Well, no, not as soon as possible, at a mutually convenient time so that we can discuss a lot of issues that I think we should discuss just with you and have a better sense of those issues. So I would like us to get that scheduled. Thank you.
Thank you, Maureen. Seth?
Thank you, Madam Chair. This is a technical question for Dwight Dunk, if I may.
Yes.
So in reviewing the proposed change to the mitigation and placement regime, I understand that what exists right now is the 22 cubic yards per linear foot average across the whole length of the project. And I certainly appreciate breaking the project up into different reaches to kind of apply mitigation sand in a way that's more reminiscent of what the actual bluff conditions are. I'm just confused as to about the statistics. So if it's 22 cubic yards per linear foot across the whole reach of the current project, and just looking at the list of numbers that's been provided for each of the 4 sections, none of those numbers are above 22 cubic yards per linear foot, and many of them are much smaller. So in my understanding of basic math, to get an average of 22, you would need some larger and some smaller. So I know that it's been presented that these formulas are what DEP and CZM and other regulatory authorities use. but I'm just confused as to how the formula could be significantly less than what's in place now. So if you could maybe just explain a little bit more about the math there, I would appreciate it.
Yes, what the framework that came out of the working group was similar to the original, similar to the NOI proposal of upon construction, building a template across above the geotubes for the full length of construction at 22 cubic yards per linear foot. So essentially filling the template, filling the tank to that volume. And then annually, before each storm season, putting that average annual contribution rate for that reach onto the template, so that that's available for each storm season. So that way there is plenty of sand on the template to serve as the on-site stockpile to recover exposed tubes, and then that stockpile gets rebuilt or refilled each fall for the upcoming winter. And it would be based on that reach and the amount that comes off the bluff, as we've calculated.
Thank you, Dwight. I know from the original proposal or order, right, the 22 cubic yards per linear foot was determined somewhat by the DEP at that point, right? And through numerous hearings to come to that number. And now you guys have kind of backed down to using a lower sand volume.
The contribution off of the bluff has always been calculated to be much less than the 22. For the existing reach, it's about 12 to 14. And it varies along the bluff as we show in those calcs. The 22 came about to provide a factor of safety on the template to make sure that there was enough sand. As we can see, over the years, some years there's more sand washed off the face and has to be refilled, pushed off and recovered. And other years there's much less. It's not a average annual. So having a stockpile that's available to take care of intense storm seasons is good. And some seasons very little is used, some seasons more is used.
Just to follow up on that, I think the idea of the 22 as a sacred number is somewhat of a myth that people have forgotten where it came from. The issue really is what's the correct way to calculate sand, and the 22 was used as a little bit of an overage when the original emergency approval or permit was issued. But the reality is because the project now encompasses a coastal bank that is of great variation in its height and in its erosion rate as you go down the length, you would naturally get a lower number as your erosion rate and bank height changes. And so I think, it was, I don't want to suggest that we need to do it because Ashley suggested it, but Ashley's suggestion of breaking up the sand mitigation into areas that have a commonality of height and erosion rate, so that there's a number that makes sense in each area, is something that is good for permitting and is good for the public to understand it and is good for the commission to understand it. And so it's not a matter of is the 22 going up or down, but it's a matter of, are you using the right formula? Do you have a safety factor in there? And then, are you making sure that you have, as your math changes, that you're accounting for it accurately. So if you get to 4,000 or 5,000 linear feet, you're definitely going to go up or down. It's just, but is it an actual change in the appropriate sand mitigation? I think it's not a change in the appropriate sand mitigation. It's just a change in the math. So, that's one of the things that I think we have put on the table as a way to help people understand that we're not trying to, SBPF is not trying to put less sand mitigation on the table. SBPF is trying to put a sand number on the table that people can understand where it's coming from, so that they can see that the appropriate sand is applied to the appropriate areas, and that the mitigation meets the standards that the Commission and DEP consistently uses in this permit and in other permits. So no one's trying to get less sand. We're just trying to make it understandable. Thanks.
Thank you, Steve. Ian has a comment, and then Seth.
Well, I do. And so thank you, Steve. But as I think the only member of the commission who actually lived in Baxter Road for decades, up near the lighthouse at number 99, we saw the 3-day nor'easters that would take between 10 to 30 feet over 3 to 4 days. And so the figure of 22 cubic yards per linear foot is a woeful underestimation of how much actually comes out of the bluff during extreme events. So I'm not arguing about the averages, although the average for these figures was taken later than when there were a number of powerful storms every year. But Ernie Steinauer calculated that during a northeaster, it was up closer to 60 cubic yards per linear foot would actually be going into the littoral system. And we saw how woefully inadequate the sand, the available sand was in the storm of the back-to-back storms of March 2018. So when you factor that in over the expanded project, it would be colossal. And so thank you.
Thank you, Ian. Seth?
Thank you, Madam Chair, and thank you to Dwight and Stephen and yourself, Ashley, for clarifying. I'm not trying to claim that the 22 cubic yards per linear foot is any type of sacred number. And in fact, I think having the project broken into reaches that matches the bluff better makes total sense. I think that there's some ways to ensure, however, that we're not only meeting the annual kind of conditions, but we're also protecting against extreme events. And one of the things that would be ideal to see is on the current project, the percentages of the template that's actually being contributed to the system each year. So we could kind of see, how much sand on the template is actually being used. And then I think, when people think about things that are, uncertain going forward into the future, for instance, with sea level rise, and you have models, you're not modeling only one scenario. You model a variety of scenarios, low, moderate, heavy. So it would be good to see not only the annual or the average annual contributions being assessed, but some other models being put forward that deal with kind of heavier erosion. And then we can maybe use one of those slightly more than average rates to kind of give us a little overage in case it is a significant storm season. I think that it makes sense for the monitoring to be, or for the mitigation to be adaptive and kind of better relate to what's actually happening according to the natural conditions of the bluff. But the worst thing that can happen is for there to be significant storm periods with uncovered geotubes. So having a little bit more than average on the template is just protection against kind of those events. So I'd like to see what percentage of the current template is being contributed, and also some of the more intense model runs showing not only what happens in the average year, but what happens in a greater than average year. Thank you.
Thank you, Seth. Any other comments or questions from commissioners? Maureen?
Mute. Yeah, I just want to say that the sand mitigation volumes, obviously, as everybody knows, has been a matter of debate for a long time. And Greg Berman, the independent reviewer of the various annual reports that we have had, it's one of the, it's my recollection that the 2018 maybe review, when that was done, again, it was a proposal by SPPF to reduce the amount being contributed every year. And there was data, and I'm sorry that I don't have it right at my fingertips, but there was data at the time from Greg, or opinion from Greg, that where the then Concom felt comfortable in insisting upon the continued use of the agreed upon portion. So it's, to my mind, and while having an adaptive process is something that makes sense, especially in something this complicated, I think that something we also need to do sooner rather than later, as I mentioned before, is to get the latest annual report reviewed and to see what's in there about sand mitigation and have it reviewed by an independent reviewer. And then I just want to say, I think Seth's comment about getting the sand source nailed down before anything else it's quite literally a threshold issue in terms of the success of each of these staggered stages, or whatever they're called, and that and because of the expense and difficulty of sourcing and the impact on the DEP's world from all the various trucks, I think getting this settled beforehand would be really, really critical. So there's a lot of stuff that I think needs to be settled on before we get too much into the weeds. Thanks.
Thank you, Maureen. Jeff?
Yeah, just to Maureen's question, I just wanted to clarify for everybody that I know we sent out that report. Mr. Berman does have that report and is working on his review of it. I'm hopefully we'll get an updated timetable from him kind of the end of this week. It's a lot of material to get through when he was trying to skim it to give an idea, but he is actively working on it.
Thank you, Jeff. Any other comments or questions from commissioners? All right, it looks like no. So at this point, if there are any questions or comments from the public, we will try and take some of those in. Jeff?
I guess I'll go first. It's kind of long, but Sam Kefferstan typed something into the YouTube chat, so I'll give it a little bit of a read for everybody. He said he would send it in, and we'll add it to the written record as well. But I'll try to get through it, so if everyone could be patient for a minute, I'll try to get through it as quickly as possible. So Sam Kefferstan from Mass Audubon, who's the local property steward for their properties, added that one of the functions of Mass Audubon's Nantucket sanctuaries is to manage our coastal waterbird program activities on island. Our program serves to monitor piping plover, terns, and other species that are protected under federal and state regulations. We are concerned that the proposed extension would encroach on map priority habitat for rare and endangered species established by the Natural Heritage and Endangered Species Program for around 800 feet. Threats to rare and endangered coastal waterbird species are expected to increase with the changing climate, particularly loss of habitat through processes of coastal erosion, rising sea levels, and barriers such as roads and other infrastructure, limiting the ability for coastal habitats to migrate inland. The structure may pose a risk to the species we are charged to protect. Mass Audubon is also concerned that the expansion of the geotubes and reduction in mitigation sand present on the template may lead to increased erosion at our Sacajawea Heathlands Sanctuary. Without proper studies on sediment transport, Mass Audubon land could be impacted through a loss of priority habitat for rare and endangered species, as well as starving of the barrier beach system at Sacajah Pond of natural sediment flows. The barrier beach at Sacajah serves as a natural buffer to protect the village of Quinnet, as well as Pulpus Road from storm damage. It is also unclear how such an expansion could impact the viability for Sacajah Pond openings in the future. If the beach becomes too narrow, openings may no longer be feasible. Additionally, past storms have washed away mitigation from the template, and the template has remained bare for days at a time. When bare, the geotubes have been shown to increase erosion on either side of the project, potentially impacting our lands. Overall, Mass Audubon supports the implementation of nature-based solutions. We recognize the need for proactive community planning to adequately address issues of climate adaptation and coastal resilience. It is clear there is a significant need to analyze this area in the short, mid, and long term given erosion and sea level rise projections. At the outset, it must be understood if this project is being proposed as an interim solution while longer term plans are being developed through a community process, or if this project will remain in place indefinitely. Those decisions are critical because underlying project studies or surveys must have those assumptions built in to adequately account for potential impact to abutters, as well as ensuring the resources necessary for success are sustainable, both financially and environmentally. Thank you for your time. So that was Sam. And then another comment from Burton Balkind. He asked the question, has all the enforcement actions taken against the proponents of the geotube project been addressed to the satisfaction of the board? And then the other commenter that's there is Megan Perry, and she had been available, still is available in the Zoom if people would like to hear from her.
Thank you, Jeff, for reading those. Would any of the members of the public who were invited in from the waiting room like to speak? Looks like no. Or do members of the commission have questions for new individuals that are on the call that might have provided comments? Also looks like no. Jeff.
Dennis's iPad, I'm sure he can identify himself, has raised his hand.
Okay. Dennis, could you just state your full name for us before you make your comment or ask a question?
Yes, thank you, Madam Chairman. Dennis Murphy from Hill Law on behalf of Mr. Greenhill. Thank you very much. I have listened intently for a couple of hours and just have 3 quick points that I'd like to make that may be relevant for the Commission's consideration. To address the question from the attorney on the panel, the case has been twice extended, the briefing schedule. It was right now is not due to be resolved until sometime in December. But this is a record review. It's a 20-page brief. In my own practice, I represent lots of conservation commissions. I've done many of these cert appeals myself. It's a weekend of work, 10, maybe 15 hours. I hope that the commission will make their decisions based on the performance standards under your bylaw and under the act, and not because of any litigation risk. I think I'm not your lawyer. Your town council told you the same advice. This is a unique situation because the selectmen are also stewards of the proprietor's beach and are playing a dual role here. And I think that if you're persuaded that there's a reason to revisit your decision, then be persuaded based on the data, on the science, on the opinion of your expert. The one thing that I will tell you that I believe will be added to the mix that has not been a consideration That is the littoral drift to the north that affects my client's property. I'm not going to talk about those effects tonight, but should there be a further public proceeding, we do intend to present evidence of that. Thank you.
Thank you. All right. Are there any questions for Mr. Murphy from the commission? Looks like no. Would any other members of the public who came in from the waiting room like to speak?
Madam Chairman, Megan Perry has raised her hand as well.
Okay, so Megan Perry, you have the go-ahead.
Can you hear me okay?
Yes.
Oh, great, thank you very much. I just wanted to thank the commission for looking at all of the comments I submitted both to the commission and to the select board. And I wasn't sure if the commission was able to see the responses that town administration gave to a number of my questions. Some were pushed forward to be discussed at the Concom meeting or asked to SBPF. And I haven't had a chance to look at Mr. Dunk's response to see if he replied to the majority of those. I'm hoping that he did. And then I think there's an awful lot in here that is puzzling to me. And I wanted to say that I support what a number of the commission members said early on. And I think you guys are doing a great job. So thank you very much for all of your time and consideration on this.
Thank you, Megan. Would any other members of the public like to speak? Looks like no.
So
Okay.
I will just add, Madam Chair, not to jump in, that anyone that submitted written comments to the board in advance of the meeting has had those comments posted, and they're available just on the regular commission's pack through agendas and minutes, and will be available, they're in perpetuity up there. And if anyone needs a hard copy, we're able to produce that at the office for them. Obviously, we want everyone to have access to that information, and if any additional information comes in, we'll obviously get it posted up to the town webpage as well.
Thank you, Jeff.
Oh, can I have one more?
Oh, yes, Jeff.
Sorry, and just as a matter of procedure, I know it's not related tonight, but since it's been asked about a number of times tonight, the existing order of conditions for SE 48, 28, 24 does require a meeting to discuss that annual report to be scheduled. So at some point in the not too distant future, obviously, I think we would want to have Mr. Berman's comments in hand before we schedule that review and have him available for that as well. But that will be upcoming, hopefully sometime. I would love to get it done before the end of the year. But we'll have to see how scheduling goes for that and how fast Greg can get that report to us.
All right.
So that's another hearing for this, or a meeting for this coming up.
Thank you, Jeff. Rick?
Can you hear me?
Yes.
I guess I'm speaking in a number of capacities, one of which, of course, was as a selectman who went through a number of years, some of which were spent with Mr. Fee on this issue. But I know that you all are inundated with a voluminous amount of reading material, and you don't always get a chance to go through them all. But I want to encourage you to read the submission by the Land Council and specifically look at the graph which outlines and makes absolutely clear what's happening to erosion from the beach. To speak about the bluff is one thing. When you have what amounts to a wall in front of it, it isn't going to erode. But erosion from the water level and using up town property, beach, is another matter. And I think the Land Council's submission helps make that clear. So I encourage all the commissioners to read that. Thank you.
Thank you, Rick. I believe that all the commissioners were provided that letter on Friday and hopefully had a chance to read it. Deanne?
Thank you, Ashley. Can you hear me?
Yes.
Thank you. I'm a little concerned here because from my understanding, there are 3 of the present commissioners who did not sit on the commission for the NOI on this proposal. And by way of looking back, Joe, I don't know if you can put my document on the screen.
Yes, give me 1 minute.
Thank you. This is a new document that we haven't submitted previously, but we, the Nantucket Coastal Conservancy, went back through the record. And I think it's important for all of us who participated in the process and also the commissioners who were not on the commission at the time, but for the NOI in this matter, there were 12 special meetings of the Conservation Commission that extended from September through June. In addition, there were 4 regular meetings when this matter was on the agenda. So that's a total of 16 public meetings spanning 9 months to cover the information related to this project. In addition, there were 53 written submissions for the record. It is an extraordinary effort. This commission, the commission that was sitting, thank you, Joe, we can take this, I will submit this document, but the commission that was sitting and heard this NOI, and there are 4 of you on the current commission, conducted a thorough and intensive review of the proposal over many months. And after lengthy deliberation, they voted to deny to permit the expansion. I take exception to Attorney Cohen's characterization that it was a close call. We don't know if it was a close call. The vote was a vote. I might also mention that the original MOU and the amendment to the MOU that was voted on by the select board was a 3-2 vote. And I haven't heard anyone characterize that as a close call. My point is, how can 3 commissioners who did not sit on the commission and hear the NOI possibly opine on whether this framework, as suggested by the working group, is something that they may approve? It just seems unfathomable to me. I think as a commission, you are sworn to follow the law and the science. And in order to do that, you need to have testimony and you need to have a record. And yes, I realize, I mean, I understand that maybe pre-hearings are normal procedure, but this is a pre-hearing for a project that has already been denied after extensive deliberation. That's my first point. My second point is that since 2011, that's 9 years ago, SBPF has submitted a number of proposals for hard armoring on the public beach below the bluff. They had Gabion 1, Gabion 2, a rock revetment. I won't go through them all, but for those of you who don't know the past history, you should understand that every single conservation commission since 2011 has denied to permit hard armoring.
So, Deanne, I don't want to interrupt, but I do want you to try and focus on the current proposal that they have in front of us, although I do appreciate the background.
Thank you, Ashley. Well, my only concluding comment would be that I think the commission does need to understand that the context of this is important, and that the reason the 900 feet of geotubes are there now was that they were permitted under an emergency order. They were then permitted subsequently as an as-built installation. And the Concom was really pressured by the select board to do that. And I think many of us are concerned that this is happening again. So we just ask the Conservation Commission to remember sort of their role, and that is to apply the law. And we don't understand how you can apply the law if you haven't had a series of hearings about the project. Thank you.
Thank you, Deanne. Joe?
Thank you. First off, Seth, you went through all the LiDAR information. You went through the entire files. Maureen, you were on Coastal Conservancy group, so you were following this. Mark Beal is a very intelligent man. I think he can quickly get up to speed by going into the meetings. I really think that's unnecessary comment. I think that the board we have now has done an amazing job. You know, I loved working with Ernie Steinhauer and Ben Shampoo and Andy Bennett, but I think that this board has done a great job. And you stated this early on, Ashley, that we look at each application very importantly. So I don't think that anything would be missed. And I think if some comment was made, I think that the 4 remaining board members would help guide someone to the information that would be lacking or a question that they may had, or Jeff or Joanne would do that as well. I don't think that something will be missed, but I also think we're here not to really discuss how the geotubes are functioning, etc. I think it's more, are we going to reopen this? That's the main point of why we're here. I thought that's what George stated. I mean, I don't mind if we have some information and some questions that if we do reopen this application, that some of the information is provided at night one. I mean, thank you, Deanne, for breaking out how many meetings we had. I didn't realize it was that many, but I didn't have a problem going to all of those meetings. It's a very important piece about Nantucket. And I think that we're here to get, as much information to, do we want to go forward or not go forward? And that's where I'm kind of at, like, I'm kind of at a point to saying, point of order, let's vote on this to see, are we going to move forward on this or not? But I do want to give a shout out to my new commissioners. I do think they will be able to, carry on and do what is right based on what is in front of us and the rules and regs. So thank you very much.
Thank you, Joe. And you are correct that the purpose of tonight is to determine whether we would allow another notice of intent to go forward on this project at this point. So that is true. Seth, do you have a question or comment?
Sure. First, thank you, Joe, for your support. I think that even for myself and the other commissioners who didn't sit on the past NOI, everything that was submitted, including the video of those meetings, is available in the public record and can be reviewed as needed. So I think that it's not relevant as to who sits on the current commission. Each one of us has the ability to apply the rules and regulations related to our jurisdiction, whether we were involved from 2011 or from just yesterday. And I think procedurally, this is to Ashley, I don't want to cut off public comment if there are more people, but ultimately it sounds like to me that we're essentially looking for a motion as to whether we agree with SPPF moving forward with a new notice of intent based on the framework provided, or we don't agree with them moving forward and we don't want to see that notice of intent submitted. Is that kind of where we're moving towards?
Yeah, so Seth, we don't actually need an official motion here. I think SBPF just wants to get an idea of whether they would be applying for something else. So it can be more of a straw poll type thing once kind of all commissioners have their questions out. And I do see you, Maureen, waving your hand. So, you know, I want to make sure all commissioners feel comfortable before we would move to make that vote or to, you know, express that opinion to SBPF. But yes, that's the ultimate kind of goal, is to do that. Maureen, it looked like you have a question or comment.
Yes, I had understood that we weren't going to be voting or straw voting or anything tonight, that this was an initial exploration of a lot of data, most of which we haven't had a whole lot of time to consider. And on top of that, I would not feel comfortable giving any kind of idea about this until we get the information on the 2019 annual report and we have an executive session with George. So I'm not prepared to say anything tonight. I think it's premature.
Okay. Thank you, Maureen. Mark?
I think we should be very careful about telling an applicant he should or should not apply. I think anybody in the town or anybody can apply for a NOI whenever they want. Now, if they get input from staff or from commissioners saying, maybe not a good idea, that's one thing, but we should never really, I think, tell an applicant, don't bother. I think that's high risk. That's not doing our job. Our job is to act on NOIs, but not say, don't bother to put one in. I think that's not doing our job.
Yeah, so Mark, I appreciate that comment and I like fully hear you there. The difference here, and Jeff or George can explain, is that this applicant has a project that was just denied. So they actually aren't allowed to put in a new notice within a certain amount of time. So this process would essentially allow them to put in a new notice, even though there was a denial at play. So it's slightly different than just kind of a new idea or a new project coming forward. Did I kind of explain that correctly, Jeff or George?
Jeff, you want to go first?
Anyway.
Jeff?
Yes, so you did, Ashley. So just to clarify for everybody, there is a requirement, there's a rehearing limit that any notice of intent that has been acted on and finally acted on in an unfavorable fashion, sorry, I can't speak, isn't eligible to apply for 3 years unless the commission decides that there has been information or substantive or material changes enough that it's essentially a different application than what was applied. So at some point, even if they applied with a notice of intent, you'd have to have a rehearing discussion. You know, I think from my end, I think looking at tonight's discussion, I think the aim of tonight's discussion was to put the concepts forward and get some feedback. And if, you know, if SBPF hears that there's concerns with those, you know, concepts to a degree where they decide that they aren't interested in pursuing a notice or putting other information to pursue it, they'd have to ultimately overcome that rehearing limit first as part of that notice of intent process. So I think, you know, hopefully that feedback is getting to them for areas of concern and questions that need to be addressed still. And they can take that feedback and make the decision that they feel best for their group. So George, if you want to add on to that, that would be great. Or if I covered it, I'd be fine too.
Yeah, that was very well said. So I would just follow up on it just to take it a step further, that you're actually not being asked to do that tonight, because that is something that's much more substantive. And, you know, all these comments are very well considered. I mean, this has only been out in the public domain and available to the commission, even except for Ashley, very recently. So you're not even at the stage where you would conduct that procedure about, you know, giving a formal vote on whether to even accept it under that provision that Jeff talked about. what SPPF was seeking was more, just to try to get a sense. Is it something that, you're receptive to hearing more on, or having more questions answered along those lines? And, Maureen's position on it is perfectly reasonable. If she doesn't want to indicate one way or another, that's her right to do as a commissioner, especially on a big matter such as this. So I think that that's perfectly reasonable. If other members of the commission wanted to weigh in, whether they think it's worthwhile or not to go forward and continue the process before them, that is something that they're free to do. If somebody is entrenched that, no, the reason that I voted to deny this project in the first place, or that I supported denial, have not been answered for me, and there's no way I'm changing my vote on it, they're free to say that too, or not say that. So it's really up to the discretion of the commission. But again, SPPF really, the purpose of this was to get out into the public what had been discussed, and SPPF's proposed changes to the project, and to get a sense from the commission whether it stood any chance of having a further hearing that would lead to possible permitting. So really, it's totally within your discretion to indicate interest in it, no interest in it, or no position on it, as Marina already articulated. But so I'll leave it to you, Ashley, if you want to ask the members individually, or if you just want to, however you want to deal with it as chair is perfectly fine.
Okay, thank you, George, and Jeff, both for explaining that. Seth?
Yeah, if I may just clarify my past comments, thank you to yourself, Ashley, and George and Jeff. I wasn't saying that we should, tell any applicant not to submit a notice of intent. I was saying that our purpose is to indicate our feelings on the framework that's being proposed. And I take Maureen's point that maybe not everyone will have a feeling tonight, but at some point, I think our role is to indicate how we feel so that the applicant knows what to do on their end.
Thank you, Seth. Ian?
Well, I also feel that that we have a responsibility to future commissioners as well as past ones to support their decisions. And the decision was to deny this, and it's going before Superior Court. So the principle of whether our local regulations will be upheld or not, I think is important, very important for both us as commissioners and the town going forward. And so that is another reason why I do not support an application truncating the process for a new NOI at this juncture. Thank you.
Thank you, Ian. Do any other commissioners, Joe?
Ian, I understand what you're saying, but at the same time, I think we have 3 new members, and I think they should express their opinions. And I understand this is a decision going forward, but I think they're on here for a reason. And I don't think they should be biting their tongue, so to speak. I think they're on here for a reason. They wanted to be on this board, and I think they should have their vote. So I don't think that we should hamstring anyone. I think, Seth, I think you and I both have had the same conversation, and you would probably agree with that statement. So yeah, I respect, Andy and Ernie and Ben's decisions and votes, and I the same, I would respect Maureen's and Mark's and Seth's. So I just think as a board, we need to hear this facts coming forward. That's why we're here, and base that decision tonight based on their beliefs, our beliefs, my beliefs, and go forward. So thank you.
Thank you, Joe. Ian?
So Joseph,
Come on, old dog. Come on, old dog.
Gotta be careful here.
I certainly, I hope that nothing I said precluded our new members from weighing in. Does anybody who, wants to object to our denials to then weigh in with new NOIs? Anyway, I won't go forward, but anyway, I just wanted to put that out there. Thank you.
Thank you, Ian. Maureen?
I guess I'm still confused. I think I can't say tonight whether I think that it makes any sense for them to go forward, because there's important pieces of data that I don't have, and I'm not used to making important decisions if there's pieces of data that can be obtained. And, so that I can make, the best decision possible. I mean, this is huge. I mean, this is a huge deal, and it's important to be fair to SBPF as well. I mean, this costs a lot of money, and obviously money is a big issue here for everybody. And I'm just not ready to do it tonight. It doesn't matter who was on the board, off the board, is back or whatever. It's too soon. And I would, very much object to us having a sense of the board, or, even something like that. I mean, I'm not prepared to do that. And I find it hard to understand why talking to our council and getting an independent opinion on the most recent report would be, I mean, it's data, it's useful information, and it would certainly help me make a decision, because I feel really, really strongly about that. So.
Yeah. Thank you, Maureen. And I totally understand those feelings, and I think it's valid, and you want to be thorough, so I totally hear you there. And I think SBPF is probably, even without an official vote or statement, probably judging how they feel like each one of us would go anyway. So I think they're gaining probably useful information. Seth?
Thank you, Madam Chair. I certainly appreciate what you're saying, Maureen. I think what really is important here is whether we think as commissioners that what's been presented in the working group framework equates to a significant and substantive change over the notice of intent that was previously submitted and denied. If we think essentially it represents an equivalent project, or what the working group submitted does not address the concerns that were raised that caused the performance standards that were mentioned that caused the notice of intent to be denied in the first place. If we think those things have not been addressed, then there's no need to move forward. Essentially, the project is the same as it was, and we can support the decision of the past commission. If we think that what's been presented equates to some significant and substantive change, then there may be a reason to move forward. So that's kind of how I see this. And I'm willing to support the past commission's decision, and I'm also willing to lend my own insight into a new notice of intent if we think that essentially a different project has been submitted. So that's how I see it. And do I look forward to having 16 meetings scheduled to potentially discuss a new notice of intent? possibly not, but I think that if that's how if the commission feels that a significantly new project has been submitted, that there's some merit to hearing it, then we'll hear it. That's our role as commissioners.
I just, excuse me, I just feel that the need to clarify something, because I don't know if I'm making myself clear, and maybe I'm not. I'm sorry to interrupt, and I know other people had their hands raised, but can I just respond to what Seth said? I'm sorry.
Go ahead, Maureen.
That I don't disagree with anything you said, Seth. I think that supporting a past decision, I mean, that's important, but it's it doesn't control everything as far as I'm concerned. And in any event, I assume that SBPF thinks this is sufficiently different that it would warrant us, giving it a good, thorough look. But I don't have any independent, data about that. I just have what they think. And I'm not questioning the quality of their experts or anything else, but, it's just, I would never make an important decision like this while I'm while there's additional data that can easily be received. Because if I were required to say something tonight, I would say no, because I don't know. I don't know enough to say yes. I need to have as complete a record as possible for me to say, yeah, go forward, because it's conceivable we might be able to approve this. But I can't do that tonight. And I won't do that tonight. And that doesn't mean I won't do it, period. But it does mean I take this, I see this as so important, and I think it'd be unfair to SBPF to rush, to rush this. So I just want people to be clear. I am not, my objections that I stated way back at the beginning, had to do with, our relative positions vis-a-vis, the strength of our case and things like that. And that to me is part of, how when you're looking at it, essentially a settlement. And so, but it doesn't mean that I think that we have to, thumbs down on them kind of no matter what. That's not what I'm saying. I want an opportunity to give this a good look, and I haven't had one. So that's where I am.
Thank you, Maureen. So we've got kind of a queue with people who are going to speak. So Dave raised his hand. Then I know I have Bruce Perry from the public, then Dwight and Ian. So Dave LaFleur, you have the stage. Oh, I don't have sound from you. You're muted.
How's that? Much better. Thank you. There's an awful lot to consider. Seth, you hit it right on the head. I think out of respect for our new members, they have to have their opportunity and time to say, and there's a lot of history and as Diane had said, a lot of records that could be gone over, and people who weren't around, members who weren't with us back then, they can be brought up to speed. I think there's some changes to this that warrant having another look and having another vote. There's also information that we need to consider coming in, and Maureen has made that point quite clear. And I know you're not asking for a hard, fast vote tonight, but I think it's worth going forward. Thank you.
Thank you, Dave. Bruce Perry, do you want to speak?
All right, I've unmuted. Can you hear me?
Yep, you're good to go.
Great. All right. Thank you. It's nice to see everybody again after a couple of years away. I submitted some comments to the board, and I think you all have it, but I wanted to add to that tonight with some things that were said tonight. First, I'd like to say that not everybody wants to see this litigation go away, as opposed to what Mr. Cohen said. I think the Concom made a well-considered decision after a number of public hearings, and it should stick with its guns and find out what Superior Court says. You know, if a judge thinks it made a bad decision and overturned you, then let the judge say that. Furthermore, I know the work groups are set up all the time, and that commission staff helps applicants file and properly and gives them advice. But I've never seen a work group present a document to the entire board and ask for their opinion. I think it puts the commission in a bad light, and its appearances. You know, it appears that the commission has already commented on the notice of intent before it's even been filed. So as I asked in my letter, that the commission just say thank you and send it back to the work group without comment. And that way there's no appearances of prejudging the application. Again, my submittal had a bunch of comments in detail. I won't go into that because they've already been here long enough. And but I don't see anything in the submittals from the work group that are substantially different from the notice of intent that got denied. A little tweaking here and there does not change the problems that such a length of geotube on a eroding bank will cause. So that's about all I got to say.
Thank you. I know Dwight, you had a comment, and then Ian.
Yeah, I was just going to comment that, you know, we started tonight with, you know, as a pre-application meeting to get some feedback on whether or not a new notice of intent should be submitted. We did not expect that the commission would make that decision tonight. I mean, if they did, that's great. If they don't, that's fine. I agree with Commissioner Phillips having a executive session with town council to discuss things before, you know, any guidance is provided makes sense. So, you know, I appreciate Madam Chair, you know, having this session. It's good to get the feedback, hear the input from the commissioners. And like I said, you know, we don't need to hear the decision tonight, but, you know, in a reasonable amount of time, and as Commissioner Phillips said, having some discussions with George probably makes sense.
Thank you, Dwight. Ian?
Thank you, Madam Commissioner. So I cannot be more succinct and to the point than Bruce Perry. And since 2013, this is, can you see it?
No, it's going into your background.
It's going into the background?
Fading away. Yeah, it just disappeared.
Okay. Well, it's approximately 6 inches of notes since 2013 on the subject. So that's all I have to say.
Thank you, Ian. All right. Any kind of final thoughts or comments from commissioners, as it does sound like we'll end up continuing this discussion? So it looks like there are not any more comments at this point. So I guess, Jeff, I look to you a little bit as far as trying to schedule an executive session before another discussion.
Yeah, so I think in lieu of trying to do that on the fly here tonight, I think I'll get in touch with George and we'll pull a few dates together, and we are allowed to set up scheduling through, you know, through email, through other provisions. So we'll get some dates together that are possible and put that together and get that posted correctly sometime in the near future. If I did that incorrectly, George, please let us know, but I think that's appropriate.
No, that's fine. I just want to give a caution, really to SPPF respectfully, is that, you know, the one thing that's not going to come out of this executive session, I can give you a preview without getting into privileged communications, is the purpose of that. I'm not going to attempt to persuade the commission that they have a weak case or that it's too expensive to continue litigating at that executive session. I'll be happy to answer questions and, legal issues involved, and, as you know, my prediction about how a court would rule and that type of thing. But, contrary to what was said about litigation and all that, I love litigation. It's what I do. It's what I've done for 31 years. So I'm not going to, my role in litigating on behalf of the commission is to advocate the commission's case in the Superior Court. And I'm certainly not going to try to convince the commission that it has a weak case and therefore it should, indicate some type of disposition toward this project proposal. The purpose of really this whole process is to just look at what they've, come up with for an alternative and see whether that stood a reasonable chance of at least being debated on the merits and, possibly being worthwhile proceeding to a permitting effort. So I just don't want to give anybody a false sense of hope, that's going to give you a lot greater clarity about whether it's worthwhile to continue the substantive discussion with SPPF about this project proposal. At that point in time, it's, like I say, it's the purpose of this is not to have a running negotiation with SPPF through the executive session process. So I'm happy to have that with you, but if SPPF does not have if they have not been provided with a sufficient read about how the commission feels about this going forward and whether it's worthwhile for them to continue pursuing it, then that's an issue. They want to take that into account, because it's not, I can tell you, I am not going to try to convince the commission that it has a weak case in executive session, because number one, I don't think that. And number two, that's not the purpose of any of this. And another thing I have to say, and you will note, hopefully, that my words at the beginning were careful about the context by which this has been presented to you. It's competing policy decisions and considerations that the select board has that don't involve your jurisdiction, that they are pursuing, the possibility of a potential resolution. Those concerns are different than yours, but the select board has never questioned the amount of legal fees on behalf of the commission, or, told me to ever do anything than 100% aggressive advocacy on behalf of any town board, including the Conservation Commission. So this is not being presented to you because the select board thinks you have a weak case or that you've spent too much money defending the case or anything like that. It's just their competing policy considerations and exploring whether there can be some type of win-win that would address concerns that they're interested in under their policy considerations. So I just want to be clear about that. The purpose of tonight was really for SPPF to get a read from you as to what your initial thinking is on this, on very limited information, as Maureen had pointed out. And I think you've said, all that you need to say about that. And I also want to express appreciation for all the commission members, being visible on this difficult remote access format that you have, so that, being fair, that they can kind of, read your body language and try to get a sense from you about what you think about all of this on a substantive basis. But I just want to be clear for the final time tonight. This is not being presented to you because we think you have a weak case or that it's too expensive to pursue. That is not on the table here.
Thank you, George. Joe?
Thank you, Madam Chair. So that through you, Madam Chair, up to the Concom staff, when you guys look at available dates, can you keep in mind the HDC? Because last meeting we had a conflict and I was going back and forth and it was tough to stay focused on both. So thank you.
Yes, we will try to provide an ample number of choices, knowing that could be a potential conflict. So
thank you.
Thank you. Ian?
Through you, Madam Chair, I'd just like to thank George for his clarification and summation of the issue. Thank you.
Yes. And I as well, thank you, George, for all of your guidance through this. Definitely need it. So Jeff, since this is a discussion item, it doesn't need to continue to a certain date or anything like that, right?
no, I mean, I think you've had the discussion, and if it needs to come back as a discussion, I mean, I think you've provided lots of, great comments and relevant feedback, that if it needs to come back for an additional, pre-application meeting or anything like that, that would certainly be at the request of, the party that wanted to discuss it again. I mean, I think, I don't want to speak for the applicant, but I think they have a lot to think about after the discussion that took place tonight. So they're a little in the driver's seat on that, and we'll see where it goes. So I don't think you have to continue or do any of those things. I think you would simply just end the agenda item and move on. It's the only thing on the agenda, so I think you could, unless George disagrees, probably just adjourn the meeting.
Yeah, I think we have like approval of minutes and some other business written on there.
We can skip all that.
Okay, well, if there are no other comments on this issue, then we will close the discussion for tonight. And as Jeff said, if SBPF wants to come back, we can open up the discussion again. So just because I am a stickler for going through things, we are in other business now. Approval of minutes. I didn't see the minutes, so.
Actually, I'm going to sign off then. I don't think you need counsel anymore.
Yeah, no, I don't.
I wouldn't want to get involved in your minutes. If it ain't broke, don't fix it.
Yeah.
I'm going to leave your meeting now. Thank you. Good night.
Thank you.
Right.
You're welcome.
I think we had intended to get those out, but we ended up not, Ashley. So I think we can.
Good night, everybody.
Good night, everyone.
We can watch
Thank
the
you, Madam
mass
Chair,
exodus
Commissioner members. We appreciate your time.
of squares.
You do it.
Good night, everyone.
Yeah, thank everyone.
Hi, Libby.
So Concom still needs to adjourn and do our stuff. So hopefully we're still on there. I don't think there's any public comment. Oh, Deanne?
Nice.
She trying to
I
make
think she said thank you using lip reading.
Okay.
Madam Chair, I move to adjourn.
Can I just say one thing? No, sorry. Maureen, I didn't mean to step on your toes, but I think if you need more.
No. I'm just
yeah.
waiting to leave.
I was like, let's go.
I'm hungry.
Yes. No, but and Maureen, have a happy birthday. Is your birthday today?
Happy birthday, Maureen.
Yes. And belated birthday to Terry.
Oh,
which was yesterday.
Wow, lots of birthdays. Happy birthday.
Thank you, Joe.
You're welcome.
Sorry to stick this on your 21st birthday, Maureen. I'm sorry.
Oh, I know. It was a big one.
Maybe you can still make it to the box in time.
Dinah, I'm hoping that I can exchange my juice for some wine. So.
Atta get your vitamin C.
Any second now.
Yeah.
So it sounds like there's no.
I want to say something.
Yes.
Ashley, thank you very much. I think you've done a fantastic job with the work group. I know it's a lot of work, and I'm sure all of us certainly appreciate it.
Thank you, Dave.
Yes.
Yes. Here.
The tough choice of watching election news tonight or attending this, or open house.
It's Mari's birthday party. Surprise!
It's all happening. Well, thank you, Dave. I appreciate that.
No. And I was just gonna say thank you to everyone for dealing with. I know it's a difficult meeting, especially when it's something that's not in our normal activities to deal with something, and I appreciate everyone's consideration and time and a little extra effort spent. And again, sorry for ruining your birthday, Maureen. Or starting the party late. Sorry. Let's have to sleep in tomorrow.
It's only 8:15. My God, it's early for us. So.
Perfect. All
Put the
right.
kids to bed.
In a
So
second, she's gonna
I'm going
leave.
to second the motion to adjourn if that's not out of order.
No, are you
No.
making that motion?
Well, someone made one, I think, and
I
then,
withdrew it, so absolutely, I did.
Go ahead, birthday girl.
so then I'll remake it. Motion to adjourn.
All right, is there a second?
Sure.
All right, so by roll vote, Beal,
Aye.
Engelborg,
Aye.
Harrisman, I, Golding,
Aye.
LaFleur,
Aye.
Phillips,
Aye.
Topham.
Aye.
All right,
Yeah,
this
pretty
meeting
well.
is adjourned.
I'm
Aye.
not sure,
See you
I'm
next
not sure
week.
where we ended up.
Happy birthday.
Thank you.
Have a good night, everybody.
Happy birthday.
Happy birthday,
Aye.
Maureen.
Good
Bye.
night.
Aye.